This is Law with Charlie, hosted by Charlie Medcalf. This is your podcast and YouTube channel for all things law, legal academia, and qualifying as a barrister.
Hello and welcome to this next podcast episode with me, Charlie Medcalf, and it's so great to be here yet again. And today we are looking at employment law, and in particular we are starting a new area of content, a new topic, which is human rights law in the employment context. And so there's a lot to cover in this podcast episode, so let's get straight into it, shall we? With starting off with what we are actually going to be covering. So by the end of this episode, you should be able to describe the different sources of international human rights legislation and how they are relevant to employment law. You should be able to explain the enforceability of the ECHR, i.e. the European Convention on Human Rights, and the HRA, Human Rights Act, in England and Wales in the employment law context. And you should also be able to explain the limitations of enforceability of the Convention rights in the employment law context, and how these may be overcome. And so, just a bit of an overview of this area, which I will be covering, i.e. human rights in employment law. This is very much an introduction looking at those topic areas that I have just discussed. And then in later episodes we will be looking at Article 4 ECHR, Article 8 ECHR, Article 9 ECHR, as well as Article 10 ECHR. But they are not the only relevant articles in the ECHR which are relevant in employment law, and many of them we will have considered in earlier episodes or later episodes, etc. And so we firstly need to distinguish between social and political rights. And so different sources of human rights legislation focus very much on different things. Some sources of international law focus on social fundamental rights, whereas others focus on political fundamental rights. So in terms of the civil and political rights, they are often found in the European Convention on Human Rights, ECHR, and that is enforced by the European Court of Human Rights in Strasbourg. On the other hand, however, economic and social rights are found in the European Social Charter, or the ESC, and that is monitored by the European Committee of Social Rights, or the ECSR, and we will be looking at that. Well, we will be looking at both the ECHR and the ESC in much more detail in just a moment. So firstly, to go into the European Social Charter. This, as I've just mentioned, contains both economic and social rights. However, it is non-binding, meaning this doesn't really have much influence at all. However, despite that, it has been used as an interpretive tool by the European Court of Human Rights. So when the European Court of Human Rights has considered cases, human rights cases in the employment context, they have reference to European Social Charter. However, the ESC is not actually binding on them or any of the countries, and there is a difference in scope between the ESC and the ECHR. As such, there are no agreements between the various states on whether the ESC should have scope or be enforceable. So some would be very much for the European Social Charter to be more enforceable, whereas other states, and I would argue potentially England and Wales, i.e. United Kingdom, wouldn't be as keen on it, because, as we will see in just a moment, the European Social Charter is very much employee friendly, which is a good thing. However, the United Kingdom has historically been more employer friendly, and actually that's a very good point, because I would argue, in my academic opinion, that in nowadays we are getting far too employee friendly to the detriment of employers, especially when we look at collective employment law and things like trade unions and industrial action, etc. But that's me going a bit off topic. And so, what are the relevant ESC rights? Well, some of the relevant European Social Charter rights in the employment law context includes Article 2, a right to work, Article 3, a right to safe and healthy working conditions, Article 4, a right to fair remuneration for decent standard of living, Article 5, a right to freedom of association, Article 6, a right to bargain collectively, Article 7, a right of children and young persons to special protection against physical and moral hazards, and Article 8, right of employed women to special protection. And so there are a few rights here which are very much specific to the European Social Charter. For instance, the right to work, right to bargain collectively, fair remuneration, right of employed women to special protection. And although there are similar things in the ECHR or domestic English legislation, it doesn't really go to this full extent of making it a human right at this level. And there are problems with various rights which I have just discussed. For instance, Article 2, the right to work. And I would agree that in the current climate of the cost of living crisis and the current world we are living in, many people would be all for a right to work. People not in power, people not in government, for instance, because, as many people will know, it has been getting much more difficult to get a job in recent times. However, getting a job is much more necessary because of the cost of living crisis. And so, allowing a right to work would ensure that people are able to get jobs. However, we need to find the jobs from somewhere and find the wages from somewhere. And that brings me on to my next point actually. A right to fair remuneration for decent standard of living. Now, in the United Kingdom, in England and Wales, we have the national minimum wage for those below 21, about between 18 and 21 I believe it is, and the national living wage. They do not reflect the real living wage though, which is the amount one would actually need in the current times, putting into consideration the cost of living crisis. And so it could be argued that under the current law in England and Wales, people are not being fairly remunerated, and they're unable to live a decent standard of living because of that disparity between the real cost of living and the actual national living wage, And so that's another problem. And we can see from Article 5 from the European Social Charter, the right to freedom of association, that is very much taken from the ECHR. So we can see here how some of the rights are almost copy and pasted from the ECHR. For instance, that freedom of association. Others build on either domestic or other international law but make them more specific, whereas others are completely new rights which many would argue are needed in current society but are very unlikely in certain societies to actually be brought into effect. And now a case to highlight how the ECTHR, the European Court of Human Rights, uses the ESC to interpret the ECHR is the case of Sidiberos and Desiaoutas and Lithuania 2004. Do excuse my pronunciation, but this was a joint appeal heard by the European Court of Human Rights. And the first applicant, applicant A, was formerly an employee of the Lithuanian branch of the Soviet Security Service, or in other words, the KGB. He later found employment as a tax inspector at the Inland Revenue. However, he was dismissed from the Inland Revenue due to being a former KGB officer. Similarly, applicant B graduated from university as a qualified lawyer and worked as a prosecutor at the Office of the Prosecutor General. He was dismissed from the job due to having the status of former KGB officer as well. So both applicant A and applicant B essentially lost their jobs due to being former KGB officers. It was held that there was a violation of Article 14 of the ECHR in conjunction with Article 8. Article 8 being the right to private and family life, and Article 14 being the right not to be discriminated on grounds of any of the other convention rights. However, it was held that there was no violation of Article 10. Now, the European Social Charter may not be binding, but it was used by the ECTHR as a tool to aid with the interpretation, in this case to reach the outcome. And specifically, it was mentioned at paragraph 47, quoted partly from Airy and Ireland, that, open quote, nevertheless, having regard in particular to the notions currently prevailing in democratic states, the court considers that a far-reaching ban on taking up private sector employment does affect private life. It attaches particular weight in this respect to the text of Article 1, subsection 2 of the European Social Charter, and the interpretation given by the European Committee of Social Rights, and to the texts adopted by the ILO, International Labour Organization. It further reiterates that there is no watertight division separating the sphere of social and economic rights from the field covered by the Convention. And so essentially, what is being said here is that although the Convention may not tackle all area of rights, for instance, the ECHR does not tackle social and economic rights, which the European Social Charter does, there's nothing stopping the European Court of Human Rights from making use of this social and economic rights and applying those or interpreting them in light of the Convention. There is no strict division separating social and economic rights from the field covered by the Convention. So moving on, we will now look at the European Convention on Human Rights in a bit more detail. And it was drafted in 1950 after the World Wars in order to prevent any other such conflicts in the future. And the ECHR provide a higher level of rights. However, the individual cannot be treated as a human. So it provides a higher level of rights because the individual cannot be treated as a human being with dignity without such rights. So, for instance, we saw in Nazi Germany how the Jewish population were not treated as human beings, and certainly were not treated as human beings with dignity. And so the ECHR very much identified how, in order for human beings to be treated with dignity, they must have rights. And so the ECHR provides for social and political fundamental rights, and it also provides for a method of safeguarding those fundamental rights to try and avoid any such conflicts like the World Wars in Europe again. So there are a number of human rights which are relevant to employment law. They include Article 4, which is the prohibition of slavery, servitude and forced labour. Article 8, the right to private and family life. Article 9, right to freedom of thought, conscience and religion. Article 10, freedom of expression. And Article 11, freedom of assembly. And so these are just some of the most relevant rights to employment law, but there will be other rights, such as Article 14, the right not to be discriminated on grounds of any of the other rights, which may also be relevant in certain cases as well. And so now let's divert our attention to the Human Rights Act 1998, and to understand this a bit more, I will go very, very briefly into a bit of constitutional law, and that essentially is that international law is not automatically the law in England and Wales, but an Act of Parliament needs to be enacted in order to give international law effect in England and Wales, or in the UK more generally. And so the Human Rights Act 1998 incorporated the ECHR into the UK domestic law. However, despite the ECHR being incorporated in UK domestic law, there is no direct effect in English law, and this is something I will discuss in a bit more detail a bit later. But yeah, there's no direct effect in English law of the ECHR, and it only has very limited application between private individuals in England and Wales. As such, other protections may apply which are applicable to private individuals, such as equality law. And so because the ECHR often does not apply between private individuals, that's why other legislation such as the Equality Act of 2010, I believe it is, provides a way to secure rights and equality in a way which can be enforced against private individuals. And there are two main methods of enforcement of the ECHR rights. And so these two methods, which can be used to enforce the rights found in the ECHR, include the courts having an obligation to interpret domestic law in compliance with the ECHR as far as they are able. And so, whenever the court is considering a case and considering the law, they must interpret that law, the domestic law, in compliance with the ECHR as far as possible. And in some cases, this will mean stretching the definitions of the domestic law where they are able and permitted. The second method of enforcement is when individuals may bring direct actions under the Human Rights Act against public authorities who have breached their conventional rights. And so this goes back to the no direct effect. Only the private individuals can only enforce the ECHR against public authorities, and it can't just be anyone, it has to be the victim of the breach who takes action against the public authorities. And so that's the second way, the second method of enforcing the rights found in the ECHR. Now, there are a number of key elements of the Human Rights Act of 1998, and this includes statement of compatibility under section 19. And so when enacting new government legislation, it must be declared that the minister believes it is compatible, but we'll go into all of this in much more detail. There's a duty of the courts to consider the jurisdiction and case law of the European Court of Human Rights under Section 2 of the Human Rights Act. Under Section 3 of the Human Rights Act, there's also interpretive obligations, and under Section 4 of the Human Rights Act, there's the Declaration of Incompatibility. So, under Section 19 of the Human Rights Act, it provides that a Minister of the Crown in charge of a bill in either House of Parliament must, before the second reading of the bill, make a statement to the effect that, in his view, the provisions of the bill are compatible with the Convention rights, a statement of compatibility, or make a statement to the effect that, although he is unable to make a statement of compatibility, the government nevertheless wishes the House to proceed with the bill, and the statement must be in writing and be published in such manner as the minister making it considers appropriate. And so essentially here, the minister in charge of the bill has to either say, provide in writing that the legislation is compatible with convention rights, or if there is a risk that the legislation is not compatible, then the minister in charge must make it clear that the government wishes to proceed with the bill anyway, and that very much upholds the principle of parliamentary sovereignty, the idea that Parliament can make or unmake any laws it likes, and so that's a key constitutional principle. Under Section 2 of the Human Rights Act 1998, a court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights, opinion of the Commission given in a report adopted under Article 31 of the Convention, a decision of the Commission in connection with Article 26 or 27, paragraph 2 of the Convention, or a decision of the Committee of Ministers taken under Article 46 of the Convention, and whenever made or given, so far as, in the opinion of the court or tribunal, it is relevant to the proceedings in which the question has arisen. And this section goes on to say that evidence of any judgment, decision, declaration or opinion of which account may have to be taken under this section is to be given in proceedings before any court or tribunal in such manner as may be provided by the rules. And this area of the statute then goes on to define what rules means and so on, but I will leave it up to you to look at this section yourself if you are so interested. Now, under Section 3 of the Human Rights Act, we have that so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. So this section applies to primary legislation and subordinate legislation whenever enacted. It does not affect the validity, continuing operation or enforcement of any incompatible primary legislation, and it also does not affect the validity, continuing operation or enforcement of any incompatible subordinate legislation if, disregarding any possibility of revocation, primary legislation prevents removal of the incompatibility. And so this is another principle of the Human Rights Act which very much upholds key constitutional principles such as parliamentary sovereignty and the separation of powers, but that is not a topic for this podcast, as this is employment law and not constitutional law, and so I'm not going to go in any more detail into this section, but if you are interested you should check out my content on constitutional law, which at the time of recording this podcast and publishing it is going to be on its way very soon. Now, Section 4 of the Human Rights Act 1998 and subsection 2 specifically provides that if the court is satisfied that the provision is incompatible with a convention right, it may make a declaration of that incompatibility. And under subsection 4 of the same section, if the court is satisfied that the provision is incompatible with a convention right and that, disregarding any possibility of revocation, the primary legislation concerned prevents removal of the incompatibility, then it may make a declaration of incompatibility. And so now I'm going to go back to what I was discussing earlier in terms of the public-private divide. And so the Human Rights Act only provides for vertical effect being between a private individual and the state or public authority. So in the employment context, only the public sector employers are covered by the Human Rights Act, and there is no horizontal effect part of the Human Rights Act. Hence, the Human Rights Act does not apply to private sector employers. So, to go into a bit more detail, when we discuss vertical effect, it's where rights apply between an individual and the state, and so you can use your rights against the government or public bodies, but not against private individuals. Whereas the horizontal effect is where rights apply between private individuals or private parties, so you can use your rights against another person or company. And so in the UK law, under the Human Rights Act, vertical effect is direct, meaning you can directly rely on rights against public authorities. However, horizontal effect is only indirect, meaning the courts must interpret and develop the law in line with the rights. And so, although technically the UK mostly recognises indirect horizontal effect, it does not recognise full direct horizontal effect, and it's only for that indirect manner that a private individual can be held liable under the ECHR in a way. But that's a bit overcomplicated. But if you are looking for a clearer, more detailed breakdown of this area, check out my premium content. More about that will be at the end of this presentation. But I mentioned just a moment ago how this public-private divide means that public sector employers are covered by the Human Rights Act, but private sector employers are not. So arguably this creates some inequality, because employees of a public employer can rely on the Human Rights Act and the ECHR, whereas private employees of private employers cannot do so. So, a bit more about indirect horizontal effect. Essentially, because courts and tribunals are public authorities, they must interpret legislation in a convention-compatible way as far as possible. So this therefore provides a way for employees to indirectly enforce the ECHR against private sector employees, because it requires the court to rule in a convention-compliant manner. However, it could be questioned that if this is fair, could it be unfair towards the employer, for instance, or even unfair to the employee when compared against public sector employees? So there's some questions I'm going to leave with you. But this is provided under Section 6, subsection 3 of the Human Rights Act, where it provides that in this section, public authority includes a court or tribunal and any person certain of whose functions are functions of a public nature, but it does not include either House of Parliament or a person exercising functions in connection with proceedings in Parliament. And so here's another case which illustrates that point of indirect horizontal effect, and this is the case of Copsey and WBB Devon Clays Limited 2005 EWCA Civ 932. So in this case, C, the complainant, was a Christian, and he refused to agree to a contractual variation which would have required him to work on Sundays, and this was due to C manifesting his religion on the Sunday. C was, however, prepared to help the defendant employer on a Sunday in emergencies, but he denied regular Sunday working hours, and so he was thus dismissed, and he appealed that dismissal. C wanted to rely on Article 9 of the European Convention. However, Article 9 ECHR was not affected, and ultimately there was no error of law. So private sector employees can raise human rights articles in relation to unfair dismissal cases. It was held in this case, but it was mentioned at paragraph 5 of the judgment that it has not been argued in this court that the article can be ignored because the complaint is against an employer in the private sector rather than a public authority employer, against whom there would be an express right under the 1998 Act to invoke Article 9. It should be recorded, however, that no concessions were made against the horizontal effect of the Convention rights. And so that's very much saying how, although it cannot be held against a private employer, it should be nevertheless recorded, and it is for the court to interpret in a convention compliant manner. And ultimately, if the individuals are not happy with the decisions and they reach the last court which they can get to, then the individuals can appeal to the European Court of Human Rights in Strasbourg once they have exhausted, as I say, all domestic remedies. However, this requires the case either getting to the last court for which there is no right to appeal, or when lower courts refuse leave to appeal to a higher domestic court, and essentially this appeal would be against the state and not the individual employers. So what is the impact on employment law? It may essentially allow domestic employment legislation to be interpreted in a more holistic way, which would extend the coverage, for instance, to social rights. So this may help strengthen employment rights. However, there may be limitations, and this could include going against the will and intention of the legislature and what they intended in the employment legislation which has been enacted. But that concludes essentially the content of this podcast episode, and so now that we've reached the end, you should be able to describe the different sources of international human rights legislation and how they are relevant to employment law. Namely, we've covered the European Social Charter and the European Convention on Human Rights. You should be able to explain the enforceability of the ECHR and the HRA in England and Wales in the employment law context. So how there's no horizontal effect and how individuals are restricted in how they can enforce the ECHR rights. And you should now also be able to explain the limitations of the enforceability of the Convention rights in the employment law context and how these may be overcome, so particularly through indirect horizontal effect. So if you have any questions, please do let me know in the comments section below, and please also go onto my YouTube channel if you haven't done so already. Watch some of my videos, leave some likes, leave some comments, and most importantly subscribe to my YouTube channel and follow me on whichever platform you listen to your podcasts on. As I'm sure I say in everything I do, by you liking, commenting and subscribing, it shows me that people are interested in this content and there is a demand for this content, and that ultimately just encourages me to keep producing such content. So please do like, comment and subscribe. Also with comments, I love hearing from my audience and I do try my hardest, and at the moment I have a 100% success rate in responding to every single comment which I have received. Now, I'm also producing premium content, so that's going through various elements of the law in much more detail, and it's the kind of content you want if you are looking at first class grades or high 2-1s. And so if you are interested in this content, please let me know in the comments below and I can get in touch with you. And then please do support me, and links on how you can support me are in the description below. But I'd like to thank you all for listening this far. I hope you enjoyed this episode, and I look forward to hearing from you all in the comments, and ultimately I do very much look forward to speaking in the next episode with Law with Charlie. Goodbye.
Thank you for listening to Law with Charlie, with your host, Charlie Medcalf. Please do ensure that you leave a comment below, either to just say hello or ask a question. And please like, subscribe, and leave a review for more content like this. See you next time.